Oke, nanti bisa sambil gantian sama temennya gitu aja kalau ada yang ketutupan. Jadi ini nanti silakan perkenalkan diri kalian, nama, terus pada role play ini kalian sebagai apa, gitu ya. Oke, silahkan dapat dimulai.
Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, Salam Kebajikan, Rahayu Rahayu. Perkenalkan, nama saya Sofia Ernisa dengan NIM 25080 saya di sini berperan menjadi Ketua Majelis Hakim. Dalam bahasa Inggrisnya adalah President Judge. Assalamualaikum warahmatullahi wabarakatuh. Perkenalkan, nama saya Lala Juga Mustikawati, NIM Akhir 0011. Di sini saya berperan sebagai Hakim Anggota berikutnya. Assalamualaikum warahmatullahi wabarakatuh. Perkenalkan Ibu, saya Syahida Mira Azamra dengan yang terakhir 219 di sini berperan sebagai Judge Member 2 ataupun Hakim Anggota kedua. Assalamualaikum warahmatullahi wabarakatuh Ibu. Perkenalkan saya Naila Zulfa dengan NIM 2508010226. Saya berperan sebagai jaksa penuntut umum. Assalamualaikum warahmatullahi wabarakatuh. Perkenalkan saya Aulia Simhani dengan NIM 2508010346 berperan sebagai korban. Saya Ayodira Tiara dengan NIM 22080100204 berperan sebagai legal counsel atau kasir. Saya fasilitasi Azadra dengan nomor NIM 25080103552 berperan sebagai saksi. Selamat siang Ibu. Perkenalkan saya Novel Celsius Jerusunan dengan NIM akhir 0206. Saya sebagai saya Kamar Pelaku Islam yang Selasa dengan NIM akhir 353 dengan peran saksi. Assalamualaikum Ibu. Perkenalkan nama saya Rosda Alizati dengan NIM akhir 342. Saya sebagai kortlek atau panitia.
Assalamualaikum warahmatullahi wabarakatuh. Perkenalkan nama saya Muhammad Syarifullah. Saya di sini membuat 250801010 yang akan berperan sebagai legal counsel atau bahasa Indonesia-nya penasehat hukum. Perkenalkan nama saya Aditya Tamar Setiawan dengan NIM 250810208 sebagai penuntut umum. Assalamualaikum warahmatullahi wabarakatuh. Perkenalkan nama saya Vito Bejan Faiza dengan NIM 25080100218. Saya berperan sebagai terdakwa.
Sudah semuanya? Oke, baik. Terima kasih dan nantinya kalian silahkan langsung ke tempat masing-masing. Berbeda dengan kelompok satu ya, kalau kelompok satu di lab, tapi karena kebetulan agenda saya yang padat minggu lalu, kita baru bertemu sekarang karena minggu lalu saya ke Malaysia dan minggu lalunya lagi kebetulan kali gawe atau tempat tinggal saya itu banjir tinggi, jadi saya nggak punya akses ke kampus hampir sekitar 2 minggu gitu. Lalu kebetulan minggu depan itu saya dari tanggal 16 sampai tanggal 22 itu di Jakarta. Makanya saya memang padatkan harus selesai hari ini. Itu ya, nanti insya Allah bisa pakai toga lagi pada semester-semester berikutnya. Ya, silahkan dapat menyesuaikan ke tempat kalian masing-masing dan dimulai. Oh iya, supaya terlihat nanti nggak perlu ada di tengah, nanti saksinya dari rada pinggir sini atau pinggir sini gitu ya, kursi saksinya.
Chronology of sexual assault case, right? With administration of illegal drugs and assault. This case began on October 12:30 at around 3 p.m. local time when the prefecture Vito visited his friend Salim who works as pharmacist. Vito only asked for drugs that would make his girlfriend Aulia pass out, with the malicious intent of raping her. Salim, who was aware of the criminal plan, abused his profession by giving Vito illegal drugs with strong sedative effect, suspected to be from benzodiazepine, class or similar. 2 days later, on the evening of November 1st around 7:30 p.m. local time, Vito came to Aulia's door under the pretext of bringing her food. From the start, Vito had mixed the drug into the food he bought. Vito then managed to enter the door under the pretext of accompanying Aulia while she ate. At around 8:15 p.m., after consuming the food, Aulia began to react feeling a little dizzy and lightheaded. As Aulia witnessed, at around 8:30 p.m., Vito began to touch her private part. Aulia, despite being under the influence of drugs, still managed to resist by pushing Vito's hand away and slapping him. Feeling angry and deeply aroused, Vito immediately retaliated with, with repeat physical violence, slapping and beating Aulia's cheeks and head. The combination of drugs effect and hard blows caused Aulia to faint. In this helpless state, Vito committed rape around 8:14 p.m. Aulia finally regained consciousness around 9:30 p.m. local time, realizing that she had been raped. With visible injuries on her face, specifically her cheeks and forehead, as evidence of abuse she had endured. The chronological has been read. Thank you for your attention. We invite the defendant's legal counsel and public prosecutor to enter the courtroom. Criminal case number 123/BID.B/2025/PN.SNE with defendants of Vito and Felix suspected of committing sexual violence rape with the administration of illegal drugs as referred to in Article 285 of the Criminal Code was declared open and open to the public at the Semarang District Court. The panel of judges of the Semarang District Court will enter the courtroom. All those present are requested to stand. Ladies and gentlemen, please be seated. Please check that the quorum is complete. After the panel of judges take the completeness of the quorum, this rule has been declared complete and in accordance with the provision of Article 23 of the Criminal Procedure Code. Therefore, the trial can be held. Visitors to the trial are told to remain calm in the courtroom, and journalists are welcome to take pictures without using flashlights. Clerk ready? Public prosecutor ready? Very good. Legal counsel ready?
Prepare your majesty.
Whether the public prosecutor and legal counsel are related by rule to the charge. The panel of judges is appointed in accordance with the definition of the chairman of the Semarang District Court in number 23. Semarang, I'm Sophie as the president judge of the Assembly Chapter and Jiga as member judge. The Semarang District Court session with SMS and gesture first-degree criminal case with this for issuing counter-transitory, swear on behalf of the defendant's article and value was declared open and open to the public. Public prosecutor, please bring the defendant into the courtroom in an uncertain condition. Yes, Your Honor. Officer, please bring the defendants, auditor and felon into the courtroom. Advocate. All right, defendants, please take your seat at the examination table. Are you in good health and ready to attend today's trial? Yes. Good. Before we proceed, I will confirm your identities. Please answer clearly and boldly. What's your name? My name is Melinda. Place and date of birth. Gender. Nationally Indonesian, correct? Address. Religion. Occupation.
Maaf, saya potong. Tadi kan saya udah bilang nggak duduk di tengah. Duduknya di pinggir. Mbak, Mas, duduk di pinggir. Biar kelihatan. Mas, tolong ini digeserin lagi. Ya, bisa diulang, silakan.
Are you in good health and ready to attend to the trial?
Okay, ready.
Good. Before we proceed, I will call for your identities. Please answer clearly and boldly. What's your name?
My name is
Place and date of birth. Gender. Nationally Indonesian, correct?
Yes.
Address. Religion.
Stop.
Occupation. Are these details correct? How long have defendants been in custody?
60 by the police and 40 days by the prosecutor.
Or they pay the police that they where were you both the time?
And the panel is
All right, Kadung Panam prison, the identities are confirmed. Now, do you both understand why you are here in court today?
I'm here because I am committed sexual violence.
Very well. Of you are here as defendants, so you must pay close attention to everything that happens in courtroom. Do you understand? According to Article 54 of the Criminal Procedure Code, you have the right to be accompanied by legal counsel. It is correct that the person seated beside you are your defense attorney. Very well. Counsel, please step forward and present your identification Guard leader of a jury at the recall of your army. Please check the document. The agenda for today, hearing is the reading of the indictment by the public prosecutor. Register, are you ready with the indictment? Thank you, Your Honor. Before that, have the defendants and their counsel received a copy of the indictment?
Yes.
Yes, Your Honor. All right, prosecutor, please proceed to read the indictment. Your Honor, allow us the public prosecutor. I, Nera Zulfa, together with my colleague, Shama, to write the indictment against the defendant Mr. Alvito in the case of sexual assault against his own.
On Wednesday, October 13, 2025, around 3 p.m., his friend Felix, who was asked for Mrs. during the meeting, Vito openly requested a drug that could make his girlfriend, Aulia, thus conscientious with the malicious intent to rape her. Felix, that being aware of the criminal intent of use her professional position by providing a strong sedative drug, suspected belong to benzodiazepine plus or similar substance. 2 days later, on Saturday night, November 1, 2025, around 7:30 p.m., Vito went to Aulia's working room under the pretext of being pursued. Without Aulia's knowledge, Vito had already mixed the sedative drug into the milk tea product. After being overcome by the victim, the defendant asked permission to stay and accompany Carol Secret. Around 8:15 p.m., after consuming food, the victim began to feel dizzy and weak as the drug took effect. Taking advantage of the situation around 8:30 p.m., the student touched the victim's private parts without her consent. The victim tries to resist by pushing his hand away and even managed to slap him. But Vito, filled with anger and lust, repelled by repeatedly slapping and punching Olia's face and head around 8:35 p.m. because was conscious.
After the victim lost consciousness, the defendant driven by lust possibly had sexual intercourse with her without consent. Around 8:14 p.m., the victim regained consciousness about 9:30 p.m., realizing sedative drug. Physical evidence included visible bruises and swelling on her face, particularly on the cheeks and forehead, as a result of the assault. The defendant's action fulfilled the elements of multiple criminal offenses regulated under Indonesian law. 1. Article 285 of the Indonesian Criminal Code, where by force or threat or force compels someone who is not his wife to have sexual intercourse with him shall be punished for rape with imprisonment of up to 12 years. 2. Article 6 of Law Number 12 of 2022 concerning sexual violence crimes. Context of sexual violence going through physical force, coercion, or when the victim is instead of the capacity of consciousness. 3. Article 351, paragraph 1 of the Indonesian Criminal Code, a Muslim comments on maltreatment shall be punished with imprisonment of up to 2 years and 8 months. 4. Article 55, paragraph 4, the Indonesian Criminal Code, those who order or assist in committing a crime shall be punished or by perpetrators. This applies to felony who knowingly provided the sedative drug as the facilitator. Defendants, have you understood the context of the indictment text district?
Yes, sir.
Do you have any response? Counsel, do you have any response to the indictment?
Since there are no changes in indictment, we would like to submit our objection, Your Honor.
Are you ready with the written objection?
Yes, Your Honor.
Very well. To the public prosecutor, the defendants, and all those present in courtroom, please listen carefully. We will now hear the reading of the objection.
Your Honor, respected panel of judges, we as legal counsel for the defendant, Alvito Bahasa, Based on a special power of attorney dated Monday, 11 November 2025, hereby file an objection or objection to the public prosecutor's indictment number case 1, which was read out at the hearing on Tuesday, 11 November 2025. We filed this objection based on the provision of Article 156, Paragraph 1 of the Criminal Procedure Code for the following legal reason. Number one, the public prosecutor indictment is inaccurate, unclear, and incomplete. The public prosecutor's indictment states that the defendant committed the crime of sexual harassment as stipulated in Article 6 of Law, number 12 of 2022, but the elements of the act are not clearly outlined. The public prosecutor did not specifically explain the element of without the victim's consent, even though this element is a fundamental element in the crime of sexual harassment. In fact, based on witness testimony and the relationship between the defendant and the victim, who had been dating for 2 years, there was an emotional closeness and consensual personal relationship, so the element of coercion cannot be simply concluded. Thus, the indictment does not meet the formal and material requirement stipulated in Article 143, Paragraph 2, letter B of the Criminal Procedure Code, which states that the indictment must accurately, clearly, and completely state the crime being charged. Number two, the indictment cannot be used as a basis for examination because the indictment is not drafted accurately, clearly, and completely. The indictment is legally null and void. As affirmed in Supreme Court jurisprudence number 48, 1969, which states an indictment that is inaccurate, unclear, and incomplete cannot be used as a basis for examination in court. Therefore, the public prosecutor's indictment in the actual case cannot be used as a basis for examining and trying the defendant. Number three, the accused acts are a personal matter that does not deserve criminalization. That the relationship between the defendant and the victim was a personal relationship within the context of a long-standing courtship accompanied by emotional closeness and personal interaction. That if the difference of opinion arose after the relationship ended, this does not ultimately constitute sexual harassment unless elements of coercion, threats, or violence can be proven. That the public prosecutor is unable to provide concrete evidence regarding the existence of such elements of coercion. Therefore, the alleged acts are more appropriately classified as moral or social issue, not a criminal offense. Based on the above, we as the defendant legal counsel respectfully request that the honorable panel of judges of the Court of Semarang District Court issue the following decision. Number one, accept and grant the defendant's legal counsel exception in its entirety. Number two, declare the public prosecutor indictment null and void. Number three, declare that the examination of case one, cannot be continued. Number four, acquitting the defendant of all legal charges. Or if the panel of judges is of a different opinion, we request the fairest possible decision. We hereby submit this accession note. We thank you for your attention and wisdom, Your Honor. The panel of judges sincerely. Legal counsel for defendant, I, Muhammad Irshad Arifullah, and my partner, Ayun Dira Pengatia, advocate law firm, Irshad and Moon. Tuesday, 11 November 2025.
Very well, the public prosecutor, do you have any opinion regarding the objection note that has just been presented by defense counsel? No, you haven't. Defendants, please return to your place. As to provide your testimony regarding the sexual harassment cast charge against the defendant, Alvito, are you willing to give your statement? To establish just one Lala Jinga, you might short the lead to all taking of the witness. Thank you, Your Honor. Before giving your testimony, both witnesses must step out according to your faith. Witnesses are invited to come forward. Please bring the witness into the courtroom in an understanding condition. Okay. Please state your full name. My name is Shaikar Muhammad Selasa. Do you both swear to tell the truth according to Islamic teaching? Yes, we do, Your Honor. Yes, we do. Okay, please be first after me. Bahasa and Shaikar. Bahasa and Shaikar. Swear in the name of Allah. Swear in the name of Allah. That we will tell the truth. That we will tell the truth. Only the truth. Only the truth. And nothing but the truth. Nothing but the truth. Okay. Now we will continue to the witness explanation stage. The first witness, please come forward. Remember, as a witness, you must speak the truth based on your saw, heard, or experience. False testimony is a crime. Witness, please state your full name and your relationship to the victim. My name is Shaikar Muhammad Selasa. I am a woman of the victim. We live in adjacent homes. What do you know about the event of the night? Around 8 p.m., I have a man advice from the road. I know he is was the boyfriend because he had visited the drugs several times before. And at first, I didn't suspect anything because they are just activated. Did you hear or see anything suspicious? About half an hour later, I heard the victim's voice as if she was existing and saying no. And then I heard shouting and something calling her. I scared, so I didn't go back ways, but I should sleep for my room. When did you decide to leave your room? About 10 minutes after the sound of the victim room stopped, I felt worried and left my room. At the time, I saw the victim boyfriend rushing out of the victim room. His first looked panicked and he didn't greet anyone. What did you do after that? After he left, I immediately knocked on the window several times. There was no answer, so I took a liberty of opening the door, turned on to be unlocked. I was shocked to see the victim lying unconscious on the floor with her clothes in syringe. And at the moment, I saw some medicine that I didn't know what it was. I was sure it didn't belong all the time because I know the victim never took medicine. And at the time, I immediately called the landlady and took the victim to the clinic. Okay, did the victim say anything after she woke up? After regaining consciousness at the clinic, the victim cried and said that she had been beaten and forged by her boyfriend. She was truly terrified and traumatized. Thank you, witness. Your statement has been recorded. The panel of judges appreciates your honesty. You must step down. Now, the court will proceed to the explanation of the second witness. The second witness, please come forward. Remember, as a witness, you must speak the truth based on yourself, heard, or experience yourself. False testimony is a crime. Please state your full name. My name is Bahasa. What is your relationship with the defendant Alvito? He is my brother. Do you know about the incident that led Alvito being accused of sexual harassment at his girlfriend's boarding house? I don't know the incident directly, and I only know after it happened. Where were you on the day of the incident? I was at home when Alvito left, saying she did visit friends, and I didn't know who or where he was. So you were not with Alvito when the incident happened? No, Your Honor, I was at home at the time. What was your reaction when you heard the Alvito was accused of sexual harassment? I was really shocked and couldn't believe it, Your Honor, because from what I know, he is not that kind of person. Why do you believe that Alvito will not do such things? As far as I know, Alvito never been to the friend, and he was fixated with his friends. Have you ever seen Elvito actively or improperly toward women? Never, Your Honor. He always reported me to everyone. Are you sure that what you have said today is true and not meant to protect your brother? Yes, I'm sure, Your Honor. I am in my truth and believe to be true. Okay. Very well. Your statement has been recorded. You may turn to sit. From the statement of first witness, it is clear that the victim did not give consent to the act. The act was done by force and hurt the victim. This court is very sorry that violence happened in a relationship that should be built on truth and respect. Love never means control or violence. Witness, please return to your place. Has there been any demand for public execution? Yes, Your Honor. Okay, please read them out.
Based on the effective of the trial and the valid evidence, we, the public prosecutor, demand that defendant Mr. Apito be sentenced to 12 years of imprisonment for witness, the time already served, and be declared guilty of violating Article 285 of the Indonesian Criminal Code and Article 6 of Law Number 12 of 2022 of sexual assault crime.
We also request that the court take into account the victim's physical and psychological suffering and provide fair legal protection for victims of sexual violence. Next, we'll read the plea text. Have your legal counsel prepared the plea text?
Yes, Your Honor.
Okay, please read. Your Honor, the honorable panel of judges, our esteemed public prosecutor and all present at the hearing, please allow us the legal counsel for the defendant of Vito Bahasa to submit this defense not affirm our moral and professional responsibility to uphold true justice. We are preparing this plea not to justify wrongdoing, but rather to clarify the facts of the case so that the actual legal facts can be considered by the honorable panel of judges in the various possible terms. From the entire set of examination and trial, the following facts were revealed. Number one, the defendant and Mrs. Aulia Islami been in a relationship for approximately 2 years. Two, on the night of Saturday, November 1st, 2025, the defendant came to the victim's boarding house with the intention of delivering food and chatting as usual. Three, when physical interaction with happened between the two, this interaction was based on the closeness and togetherness that had happened frequently. Four, there was no element of coercion, threats, or violence as alleged by the public prosecutor. And the last part, following the incident, their relationship continued smoothly until misunderstanding arose after their relationship ended. These facts are supported by witness testimony and evidence presented at trial, which do not support any element of sexual violence. The public prosecutor charged the defendant with Article 6, letter of law number 12 of 2022 concerning the crime of sexual violence, the main elements of which are one, an act of a sexual nature, two, perpetrate against another person, three, without the victim consents, four, by means of violence, threats, deception, or both abuse of power. However, based on the result of the trial examination, the element without the victim's consent was not legally and constitutionally proven. Victim herself did not state any physical coercion or threats in her statement. The relationship between the defendant and the victim was based on emotionally closeness and mutual trust in the social and cultural context of our society. Is often misinterpreted after the relationship ends in disappointment. Therefore, the action alleged by the public prosecutor do not fulfill the element of the crime of sexual harassment as referred to in the indictments. According to the principle of in via pro reo, if there is doubt in the evidence, then the doubt must be allowed in favor of the defendant. The honorable panel of judges certainly understands that criminal evidence must be valid and convincing. Because in this case, there is not strong and convincing evidence of violence. The defendants, furthermore, Article 183 of the Criminal Procedure Code explicitly states a judge may not impose a penalty on a person unless, based on at least two valid pieces of evidence, he or she the conviction that a crime has actually occurred and the defendant is guilty of committing it. The fact at trial actually case results in the public prosecutor charge is failing to meet the evidentiary requirement. Your Honor's panel of judge, we believe. Okay, next, there will be a legal copy. Is the legal officer ready?
Yes, Your Honor.
Okay, let's read it.
Your Honors, the respected panel of judges, or respected public prosecutor, on the legal facts revealed at trial contain erroneous assessment of the evidence and witness testimony. The public prosecutor, in her reply, remains adamant that the defendant is been proven to have engaged in a sexual harassment, as referred to in Article 6, letter of the law number 12 of 2022 concerning crimes of sexual violence, citing sufficient evidence and testimony from the victim. However, Your Honor, panel of judges, we consider the public prosecutor argument to be presumptive and not based on legal evidence. The prosecutor will rely solely on the victim testimony, ignoring inconsistency and contradiction between the victim testimony and the evidence that other witnesses present on the trial. Number one, the element without victim consent is not proven. The prosecutor believed that defendant action were committed without the victim consent. However, the fact at trial actually showed that the defendant and the victim had a long-standing relationship in which physical interaction between them had occurred several times voluntarily and without coercion. The testimony of witness ay kami tahu ay sinabi niya sa nata, and pada yasa si Azara also confirmed that between two was close and mutually affectionate, and they were often seen together. Therefore, the element of non-consent was not legally and convincingly proven. Number two, no elements of violence, threat, or coercion. The prosecutor assessed that the defendant exerted psychological pressure on the victim. However, there was no evidence or witnesses to support this claim. There were no physical signs, evidence of threat, or report of violence indicating coercion, as required by the sexual violence crimes law. Therefore, the element of coercion was not met. Three, inconsistent victim statement. There were significant discrepancies in the victim's statement in the examination report and in court. On the one hand, the victim stated that she felt coerced. However, on the other hand, the victim also admitted that the incident occurred on a friendly atmosphere, and there was no direct threat. This inconsistency raises legal doubt, which should favor the defendant under the principle of indubio pro reo. According to Article 183 of the Criminal Procedure Code, the judge may not impose a sentence unless based on at least two pieces of evidence. He or she is convinced that the crime actually occurred and that the defendant was the perpetrator. In the case Apple, the evidence presented by the prosecutor was insufficient to convince the panel of judges because one, there was no post-mortem examination of any physical violence. Two, there are eyewitnesses who support the defendant alibi. Based on this fact, the element of the crime of sexual harassment were not legally and convincingly proven as charged by the public prosecutor. If the honorable panel of judges has a different opinion, we request that you consider the following mitigating circumstances. Number one, the defendant regret the misunderstanding and has apologized to the victim. Number two, the defendant is young and has never had any previous legal dealings. Number three, the defendant behaved politely throughout the trial. Number four, this case arose from a misunderstanding and personal relationship, not of malicious intent. Based on all of the above, we as the defendant legal counsel humbly request that the honorable panel of judges of the court of Smart is report decide as follows. Number one, accept and grant the defendant's legal counsel the submission in its entirety. Number two, reject the public prosecutor entire rejoinder. Number three, declaring that the defendant Alvito Garza Bahasa has not been legally and convincingly proven guilty of committing crime as charged. Number four, acquitting the defendant of all legal charges. Number five, restoring the defendant's right in terms of ability, status, dignity.
Has the public prosecutor prepared a legal reply?
Yes, Your Honor.
Yes, please read.
Your Honor, we reject all the defense argument as they are false and inconsistent with the evidence presented in court. The defendant essentially refers to the element of violence and coercion as regulated in Article 285 of the Criminal Code and Article 6 of the Sexual Violence Crimes Law.
We state by power of privy the sentencing domain of 12 years of imprisonment for the defendant. Here is the reading of the interim discussion. The public prosecutor, legal counsel, and defendant are to listen carefully to what the judges read in this interim discussion. In the name of justice, under the Almighty God, the District Court of Samara, having assigned and tried the criminal case for an ordinance for the 28th Monday, November, delivered the following informative discussion in case of 1. Identity of the defendant, name Albitu, place and date of birth, Samara. Gender is male. Nationality Indonesia, religion Islam, occupation studied, address Makassar, Sekarang, Jumat, Semarang. In the mind by the public prosecutor. That the public prosecutor of the Semarang District Prosecutor Office has filed in indictment against the defendant Alviko Living Death. On Saturday evening, or at the boarding room of the victim Aulia, the defendant committed an act of sexual violence by touching and forcing the victim to engage in sexual activity without her consent. The act is fraudulent and punishable under criminally charged. Article of Indonesian Criminal Code, substitute charge, Article of 6 of Law on sexual violence crimes. That the defense counsel submitted a written objection, stating mainly that number 1, the indictment is unclear and impressive, particularly regarding the element of violence. Number 2, the element of force under Article of the Criminal Code is not properly signed the relationship but when the defendant and the victim was consensual. Number 3, therefore, the defense counsel requests that the court declare the element null and void or at least inadmissible. That the public prosecutor is respond or agreed that number 1, the indictment was properly and clearly and accurately article. Paragraph 2 of the criminal procedure. Number 2, the activity of a personal relationship does not eliminate the element of person as the victim clearly respect and suffered physical violence. Number 3, therefore, the public prosecutor requests that the court reject the plea entirely and confess the case to trial. The court having carefully examined both the objection of defense counsel and the process responsive of the opinion that 1, the indictment met both formal and natural requirements as stated in Article Paragraph 2 of the Criminal Procedure Code. Signed is included the defendant, identity, time, and place of the crime, and a clear description of the alleged act. 2, the claim that the relationship between the defendant and the victim was consensual is a matter of evidence, which must be examined during the trial on the merits. Number 3, therefore, the plea submitted by the defense counsel has no legal basis to cancel or inflate the indictment. The court hereby decides 1, to reject the objection of defense counsel is elementary. 2, to declare that the indictment of the public prosecutor is lawful and acceptable. 3, to order the trial continue to the state of evidence examination. This internally discussion was pronounced in open court session on Monday, November, by the panel of judges of the Semarang District Court, President Judge Selasa, Member Judge 1, Jingga, Member Judge 2, Chandka, with the assistance of Bunga and the President of the public, the defendant and defendant counsel. The hearing is adjourned and will come with the exhibition of minutes of the next session. Public prosecutor, please bring the defendants into the courtroom in unprecedented condition. Yes, Your Honor. Officer, please bring the defendants, Alviko and Feli, into the courtroom. One second. Madam, We will now give features demanded before the panel of judges. Are you in good physical and mental condition today? Very well. Before giving your testimony, you will first be sworn and you will execute just to check. Please first believe the victims. Will I be good? That I will be good. I swear that I will tell the truth, the whole truth, and nothing but the truth. Right, madam, are you in good health and ready to attend today's hearing? Yes, I hope I'm ready. You are. If I may ask, what happened to your face in Chile? I was and you are not right here. Okay. I see. Are you still able to participate in the trial today? Yes, I am. Please show your identification card. According to Article 160, paragraph 2 of the Egyptian Criminal Procedure Code, before giving testimony, we must first confirm your personal identity. Please answer correctly. Yes, Your Honor. Name? Always Imani. Please and date of birth. When? September 10, 2016. Religion? Gender and nationality? Female Indonesian? Correct? Correct, Your Honor. Address? Petition? Students. Do you know the defendant? Yes, I do. It is my boyfriend. Are you still in a relationship with the defendant? Yes. Please come forward. All right. Please tell the court what you know about this case. Yeah, Saturday evening, of my engagement to my people. After I visit the game, I start to feel busy. He began coaching my pivot area. I resisted, but he hit me back. After that, I was conscious as Yana. Have you seen men like this happen before? No, Your Honor, but he has probably hurt me before. Okay, thank you. To the public prosecutor, do you have any question for the victim? Yes, Your Honor. Miss Aulia, are you certain that the person calling the egg was the defendant person in this courtroom? Yes, Your Honor. I still remember the facts clearly. Very well. Did you receive an apology from the defendant after the accident? No, Your Honor. When I began continuous, my boyfriend Pico was no longer at the scene. Understood, Your Honor. No further question. Counsel for the defense, do you have any question for the victims?
Yes, Your Honor. Madam, are you absolutely certain that the incident was not accidental or driven by impulse?
I was certain, Your Honor. The death was intentional. It called have an accident.
Very well, Your Honor. That is all from us.
All right. With that, the explanation of the witness and the victim is hereby concluded. I written deposited to the presiding judge. In the name of justice, based upon the belief from the NLT law, the panel of judge of the Smart is the report. Having its mind entered the criminal case in the name of the defendant of the Bahasa, after carefully reviewing all evidence and hearing the testimony of the witness, the victim, and both parties, Harvey delivered the following statement. Number one, declares that the defendant Alvaro Aguilar has been guilty and confident proven guilty of committing the criminal act of physical sexual harassment in a public place, as revealed under Article 6 in conjunction with Article 10 of Law Number of on Sexual Violence Crimes. Sentence number two, sentence the defendant to imprisonment for 2 years with a period of detention already served to be deducted from the sentence. Number three, orders that the defendant shall remain as constant. Number four, declares that the defendant consenting footage, false report, and witness statement shall remain in the case file. And the last number, orders the defendant to pay court food and maintain 2,000 rupiah. Do you understand the context of the verdict that just been read up? Do you understand? Okay. You know, place to move your future. Farewell. Signs. Both parties have activated the discussion. The criminal trial in name of the defendant, Alvito Aguilar Faita, is hereby declared confident.
As concluded by the presiding judge and with the conclusion of today's trial, I, as the court clerk, hereby report that the verdict in the case of sexual harassment committed by the defendants Africa and Faiza has been lawfully delivered and accepted by both parties. The meaning of the verdict will be documented and signed by the presiding judge, the panel of judges, the public prosecutor, and defense counsel, and myself as a court clerk. The counsel, the official report of the trial held at the Smart District Court on this day may justice always guide our action. And the court session is officially closed. Thank you very much.
Oke, silakan ke tengah semuanya, ke tengah dulu. Yuk ke depan lagi. Tepuk tangan lagi dong, lebih meriah dong. Oke ya, terlihat dari persiapan, ada yang pakai bajunya juga disesuaikan, dan juga walaupun baca tapi intonasi, pronunciation-nya, dan kedengeran gitu loh, keras keras turun intonasinya, itu juga bagus banget. Sejauh ini dari 3 kelompok, kelompok 3 yang paling bagus. Nanti bisa dicek di YouTube, kalian bisa melihat diri kalian sendiri dan nanti bisa beri apresiasi ke diri kalian sendiri kalau kalian juga sudah melakukan hal baik ya gitu. Walaupun mungkin ada 1-2 hal yang tidak sesuai dengan rencana, misalnya pengennya di ruang sidang, tapi ada hal kendala yang lain, tapi nggak apa-apa, nanti bisa ketemu lagi gitu ya. Saya juga apresiasi pada hakim ketuanya gitu. Kayak kamu udah speech atau belum sih?
Belum.
Oh iya, pantesan. Saya kok kayak kok dia bagus tapi kok saya kok nggak hafal ya, nggak tahu ya. Oh, ternyata kalau kamu belum, jadi saya belum tahu gitu ya. Oke, nggak sabar untuk menyimak speech dari kamu. Hakim ketuanya juga baik sekali ya dalam menjalankan role play-nya gitu, dan tentu saja the one and only Rashid ya, gitu juga bagus. Irsa juga, tapi nggak apa-apa. Namanya kalian kan juga teman-teman, saling membantu, saling membangun, jadinya tetap belajar. Oke, mungkin sebagai closing saya selalu minta dari kelompok yang maju vocab aja dua atau tiga yang kalian ketahui atau baru ketahui dalam skrip kalian gitu. Jadi bisa disampaikan mulai dari irsyad sampai ngemasnya dan kalau bisa antar temennya beda ya gitu. Nggak perlu melihat skrip kalian. Kan sudah tadi udah ngomong terus. Jadi kan sudah catch udah ngenangkep gitu loh. Silahkan irsyad.
Yang pertama, Bu, saya baru aja mengetahui kata indictment. Mana artinya terdakwa atau tidak Bu. Selanjutnya ada defendant, ternyata terdakwa itu. Selanjutnya ada insane. Tahan. Dan dari saya terima kasih.
Kalau dari saya itu ada dua vocab. Yang pertama itu malicious, itu tuh ternyata artinya jahat. Terus yang kedua ada injure, itu artinya yang ini melukai. Baru.
Kalau dari saya, kalau yang pertama itu ada trade, yaitu melakukan perdagangan, dan yang kedua itu ada convincing, yaitu meyakinkan. Kalau saya ada deliberate, Bu, jadi kayak mengulangi itu aja bagian saya. Kalau saya defendant sama persidangan, kalau defendant itu terdakwa atau pelaku, kalau persidangan itu majelis kehormatan. Kalau saya safety-nya artinya menolak sama sanksinya mau menahan. Oh, jadi saya cuma satu ya, jadi kalau itu ternyata tidak sopan. Kalau saya itu dakwaan sorry banget.
Indictment. Yuk.
Kalau aku
Oh, kamu nggak nonton Korea apa gimana? Kamu baru prosekutor tuh kan? Oke, lanjut.
Aku lagi
Hmm, apa itu? T. Lanjut. Oke. Apakah ini namanya trial atau mock trial? Kalau mock trial tuh apa sih? MOCK. Jadi sempat muncul tuh. Belum tahu ya. Oke, nanti dicari tahu ya artinya. Itu seperti ya kayak pura-puranya, sidang tapi pura-puranya. Mock trial. MOCK trial. Mock trial. Gitu. Oke, saya cukupkan. Walaupun tadi saya mention beberapa role, tapi overall kalian semuanya baik. Saya bisa melihat persiapan kalian. Jadi semua hakimnya, semua saksinya, semua attorney-nya, semua prosekutornya, semuanya baik gitu ya. Jadi jangan kok yang dimention hanya, ya itu namanya kita perlu memberikan apresiasi atas beberapa role, atas beberapa bagian yang memang perlu diberikan. Tapi secara keseluruhan kalian baik semua dan mempersiapkan ini dengan baik. Itu ya. Oke, applause sekali lagi. Oke, saya tutup, saya akhiri. Assalamualaikum warahmatullahi wabarakatuh.
Minta foto